Welcome to Simply Separated. Let's talk about separation and divorce. I'm your host today, and my name is Marian Grande. I'm an accredited family mediator, divorce coach, and founder of Absolute Dispute Resolution. Today, we're going to talk about family mediation versus family litigation. There's a difference. Do you know what the difference is? Do you know which helps you more? Do you know which one you should go to? A lot of people don't, and today we are going to discuss it. Many people assume that the only way to resolve a family law matter is to retain counsel and to commence a court action. This is a wrong assumption. Some cases must be settled with court intervention, but many cases do not need court intervention. Did you know that litigation is extremely time-consuming, emotionally draining, expensive, unpredictable? It is. Mediation is not. What is mediation? Well, mediation is an alternative to court. It employs a third party who has been professionally trained and educated in mediation and negotiation. That third party is called a mediator. The mediator does not judge the case, but helps facilitate discussion, limits the issues, and puts them into perspective to assist the parties in resolving the dispute. A mediator will never make a decision for you. A mediator doesn't act on behalf of either party. A mediator is a neutral third party, and the mediator will remain so throughout the whole process. It's important that once mediation is concluded and the mediator draws up your document, whether it's a memorandum of understanding, minutes of settlement, or separation agreement, that you bring it to a lawyer for independent legal advice. You want to make sure that what you have decided on ensures your rights are protected legally. Also, you have to remember that if anything is ever challenged at some point later in court, if the lawyer has signed the certificate of independent legal advice, your agreement stands on stronger footing, meaning a judge may be less likely to set that agreement aside. Mediation is less expensive, more confidential, and highly effective in resolving conflicts more peacefully than expensive and stressful litigation. Well, let's talk about a retainer. What would a lawyer charge for litigation for a retainer? The norm is between $10,000 to $15,000 per person. Mediation, $1,000 to $2,000 per person. Also, for a lawyer, you're looking anywhere from $350 an hour to $950 an hour per person. It is unlikely, very unlikely actually, that in a family litigation matter, you will get away without spending between $25,000 to $100,000 in litigation. 25 being rare. Let's talk about mediation. Retainers range $1,000 to $2,000, but the mediator's fees are also less. They're usually $200 to $300 per hour per person. What that means is ultimately you end up with a total bill of $1,000 to $7,000 for your mediation, depending on the length of your mediation. Court can take anywhere from 2 years and up. If you're going to trial, even longer. Mediation can last a day, 2 days, a week or two, maybe 4 months, maybe 8 months. But it shouldn't take much longer than that. And a good mediator will always advise you that if you're going through the mediation process and it is not working, that you and your partner may want to look at another alternative, being court. It takes time to get to a family law trial. It's very extensive, and the reason it's so expensive is because so much work is involved for the lawyer. Let's talk about the new Divorce Act that came out last year. In the Divorce Act, it's very clear in that it says lawyers should be referring their family law clients to mediation first. Keep in mind that if you don't go to mediation first and you do have your first appearance, a judge will most likely want to know why you have not gone and spoken to a mediator or tried mediation, and they may actually order that you do. It's really important to speak to a mediator first. Why is that? Well, the mediator can tell you right away whether your case is suitable. Not all cases are suitable for mediation, and you want to remember that. Some cases, such as domestic violence, some cases where there is an extremely strong power imbalance, may not be suitable. But it's worth it for you to speak to a mediator, and they can guide you. And they could probably refer you to a good lawyer if the case is not suitable for mediation. Another thing to keep in mind is, when you go to court, you're not making the final decision. A judge is. And you have to remember that a judge will never know your family as well as you do. The judge does not know your family dynamics, does not understand how your family works day to day. They don't understand your children. They don't understand your kids' routines and what they're going through. And that's why you're leaving it in the hands of a third party. Most likely the outcome will not be favorable to one of you. Remember, there's no winner or loser in mediation, but there is in court. Someone always wins and someone always loses. Mediation, you both can walk away winners. You're formulating your own story. You're formulating what goes on next in your family. Yes, you're separating. Yes, you're getting a divorce, but at the end of the day, you still have a family. You may have kids. What happens to the kids? A mediator can help you with things like a financial statement, child support, spousal support. A mediator's trained in all these things. It's important to be honest with your mediator. It's important to lay all the facts on the table. Nobody wants any surprises at the end, least of all the mediator. But also keep in mind that court is a good alternative for certain cases. Certain cases do require the strong hand of a judge. And that's just the way it is, unfortunately, sometimes. Financial statements are also very important when you're dealing with family law. I strongly urge people going through mediation to complete financial statements. One of the reasons is it's all in black and white. You possibly can't remember everything financially that happened in the term of your marriage. Some things may be left out inadvertently or sometimes on purpose. And also, when you bring your agreement to a lawyer for independent legal advice, 99% of the time, a lawyer will want to see a financial statement. They will give you legal advice, but they need to see the whole picture. And it's so important. Although financial statements are not mandatory in mediation, they are highly, highly recommended. I hope we gave you a little bit of insight to the difference between litigation and mediation. I do want to mention one last thing, and that's the privacy of mediation. It's a private proceeding. It's called a closed mediation. There are open mediations, but both parties have to agree to it. But 99% of the time, mediations that I've done have always been closed mediations. Court is public record, and you have to remember you're dealing with extremely sensitive issues of yourself, your spouse, and your kids, and anyone has access to that information. In mediation, it's private. Even if your case goes to court later on at some point, what was discussed in mediation cannot be brought up. It is private between the both of you, and a mediator cannot be compelled to give evidence unless there has been violence or threat of harm, things like that. A judge can order the mediator to speak in those cases. But overall, mediation is a far better process, and it helps with co-parenting. Remember, that relationship with your ex goes on for many years to come, especially if you have small kids. You want to make sure that you have a good co-parenting relationship so that you can discuss the issues revolving the kids' school, health, things like that openly with your ex. If you go to court and most times you end up feeling very bitter towards the other person, it's extremely hard to communicate with them later on a co-parenting level. So anyways, I hope this gave you a little bit of information. It's just touching the surface of litigation versus mediation. In future episodes, we will dig deeper, but we welcome any comments. And thank you so much for joining us today.